Fresh admission. Item number 1.
My lord, may pass the similar order.
Similar order.
Would you be able to file a repeat?
All right.
My lord, only I request to in a time bound manner, my lord.
No.
No, my lord, I honestly pray your lordship because the other matters are there. Yes. These are all policy matters. You should not file writ petitions.
Item number 2.
Please, my lord. My lord, here the writ appeal also arises out of an order passed on 4/1/2022, passed by the Honorable Single Judge. My lord, one end he has said that liberty has granted to file a contempt petition, and when the contempt petition was pending, and we have filed a writ petition saying no. Once the contempt has been disposed, the contempt was at that time was pending, not disposed of. Saying no, contempt petition has been disposed of, so writ is not maintainable. So far, the fact of the case is concerned like this, my lord, that some illegal encroachers, they are encroaching the government.
What happened in the contempt petition?
Contempt petition thereafter, after disposal of the writ petition, contempt petition has been disposed of. But when the writ petition was disposed of, the contempt petition was pending.
Anyway, so now why have a writ appeal then? Contempt petition already you've pursued, it's been disposed of.
No, the same honorable judge granted liberty to file a contempt petition. We have getting the liberty from the honorable judge, we filed the contempt petition. Contempt petition was pending. Honorable single judge, not only that, the another judge, he has directed the state council to file the compliance affidavit. Different adjournments they have taken, not file any compliance affidavit. There was the change of assignment. When the assignment was changed, immediately the honorable single judge said, no, once the contempt proceeding has been dropped, nothing is survived to decide.
The contempt petition has been dropped.
At that time, contempt petition was pending.
Sir, I need to answer the question.
Sir.
Ultimately, what is the order in the contempt petition?
Contempt is ultimately dropped.
Why?
Why it has been dropped? There was a contrary opinion. Tahsildar says something, RI says something. Tahsildar says no, encroachment proceeding has already been initiated. Eviction proceeding has been. RI says no. Eviction proceeding has not yet been initiated. Only the encroachment proceeding has been initiated. Only pen and paper. Practically, the eviction proceeding has not yet been initiated because they are encroaching.
You want to find out what's happening? Ultimately, he wants those encroachers to be evicted.
Yes.
That's all.
So that is the sole purpose. Once there be encroachers to be evicted, then my prayer is nothing is there.
All right. Counsel to the appellant states that despite orders, eviction proceedings have in fact not been eviction proceedings vis-a-vis the encroachers. That is respondents. You implemented them here, sir?
No, the encroachers who have not implemented here.
What do you mean, sir? Then there's the question. That itself is gone then.
Sir, that is the sir. Yes, I have stated their names, sir. I have stated their names in the
you know best. Without notice to them.
No, notice also given. RI submitted their notice. They have here in a compliance affidavit. RI said we have served the notice to the encroachers. All encroachers have been noticed.
Mr. Pandey, I don't think you're following what I'm saying.
Sir.
Whether RI issued notice or not is one thing. In these proceedings, in this court, without notice to them, no order can be passed. You may have done it in the RI's proceedings. RI may have given them notice. RI may have.
But
today, if you want an order, you have to implement them.
With my liberty, I can also amend the request.
No. That's not. You say it's a fatal defect, sir, in your writ petition itself.
This is writ appeal, sir. This is a writ appeal, not writ petition. Writ petition.
I see. We don't know it is a writ appeal, is it?
Sir.
You're trying to tell us that we don't know this is a writ appeal.
Yes.
It's a fatal flaw in your writ petition that you did not implement these encroachers as parties. This is what we're trying to tell you. You say the appellant wants the relief of eviction of encroachers without implementing those encroachers as parties, even in the writ petition. Full stop. This is fatal to the writ petition much more and a fortiori in the present writ appeal. Consequently, the court is not prepared to entertain the present writ appeal. It will, however, be open to the appellant to seek other appropriate remedies, ensuring that persons against whom he is seeking orders are implemented as parties in those proceedings. All right.
The contempt is also in list.
Yeah, contempt, you say this has to go before the single judge.
No, this is disposed of because
Then it's okay. That's all right. We don't have to pass an order.
Item number 3.
May I please, Your Lordship? Your Lordship, on behalf of CS Panda, we have filed the caveat and a copy of writ appeal may be served.
I'll serve a copy, my lord. In the similar cases, the lordship has stayed it.
This is first day disposal.
No, my lord, this is not first day disposal. This is the first day disposal relying the order of earlier case. So in similar case, your lordship has stayed it and fixed it. Your lordship, I have given that copy and has stayed that order.
No, when is the next date here?
I'm telling. For my lord, 13th April,
1-3.
my lord,
All right.
13th April.
Same order 1-3. You accept notice, put down her name. You've given your name.
Yes, Your Lordship.
Just put it in a slip of paper, your name, please. Yes.
4.
My lord, this is the regularization matter. Your lordship has already issued similar matter. Your lordship has issued, and your lordship next date is fixed to 25th April, my lord.
Same order.
Relating to
25th
my
April. All right.
4, 14, 16, and 45 are same.
4, 14.
16 and 45.
All right.
5.
In this case, my lords, I'm appearing for the caveat, my lords. Similar matters, your lordship, please to post it on 14th of March, my lords.
Yes, my lord.
All right. List on 14 March.
But item number 5, 8,
8,
9, 10, and 12.
All right.
No.
Yes,
Yes, ma'am.
6.
different, my lords.
It is more than monetary limit, the demand is more than 25 crores.
Right.
But what's the delay in this review petition? There's no delay.
Delay petition is filed. $25 crores, 91 lakhs, 59,940.
No, this is the general letter. All right. It is pointed out that the tax effect is beyond the monetary limit fixed by the circular number 3 of 2018. In that view of the matter, the order dated 19/11/2018 is recalled and ITA 115/2013 is restored to file. Now come to the main ITA, sir.
Yes.
Question of law. Voluntary contributions received by the assessee society was not taxable. So what happened to the assessee's own case? Come to page annexure 3, sir. Annexure 3, page 22.
The file is not with me. Let you to come on some other date.
Unless you tell us what's the, you say it is seen from the impugned order of the ITA team that an appeal has been filed in this court in the assessee's own case for AY 2007-08 against the ITAT's order dated 21st January 2011. Paragraph, counsel, Mr. Chimankal and standing counsel, the department seeks time for instructions on the present status of the said appeal. At his request, list on March 21st.
Seven. Your Honor, inadvertently, we could not file the postal request. Your Honor, in course of the day, we will file.
Not able to hear you, sir. Speak into the mic.
Inadvertently, we could not file the postal request. In course of the day, we will file it.
This is a 2021 appeal, sir.
My lord, it is against the order of the single.
And we are filing requisites today, my lord. So this is the, my lord, order passed by the honorable single judge without following the uniform policy prevailed by the temple managing committee, the policy which was prepared by the managing committee in consultation with the state government for disposal of the property of the Lord Jagannath, my lord. And without the honorable single judge, my lord, considering the policy in its proper way, my lord, directed the temple administrator to execute the registered sale deed in favor of the petitioner after 12 years, my lord. If the lordship turn for a moment, that impugned order, page 90 of your lordship's brief at annexure 5. Annexure 5, you will see the order passed on 8/4/2021. The writ petition filed in the year 2008, my lord, where the temple administration getting approval from the state government directed the petitioner to deposit the amount of 13,91,500. That is the value we have determined. My determination value is prepared by the uniform, my lord, under the uniform policy chairman, district level at some committee is the headed by the chairman, the collector is the chairman, my lord. They have prepared the market value and we have approved it from the state government and issued a letter to the petitioner to deposit this much of amount. That was challenged in the writ petition in the 2008, my lord.
All right. You said, was there a stay granted by this court?
Stay not granted, my lord. It was inadvertently overlooked. This may directed to stay the impugned order. Now contempt they have initiated.
No, but that was to be adjourned beyond the date fixed by the court. That's the interim.
Your lordship, my lord. That was adjourned.
Counsel for the appellant undertakes to file the requisites during the day course
Yes,
of the
in
day.
course of the day.
All right. Interim order to continue. The requisites be utilized for service of notice on the respondents by registered speed post. Returnable on the next date.
Much over.
List on 12th September.
Much over.
Account 11.
This matter, my lord,
Delay is condoned, dispensed with. That's allowed.
your lordship, I want to withdraw that the table with the liberty to file a review.
So, and this order. That's it. All right. After that, you pass. Right. In 10, you say no instructions disposed of. 10 is state's appeal.
Sorry, sir. Single. 5, 8, 9, 10 similar.
5, 8, 9, 10, 12.
12. Account 13.
Disposal is not pressed. All right.
15.
15, 18 and 22, all are similar. My lord, I have been instructed to appear on behalf of appellant. A copy of
Appellant.
respondent. Copy of the appeal memo may be served on me.
Letter has been fixed to 14th March.
All right. List on 14th March.
17.
President appellant is the petitioner for the honorable single judge challenging the impugned order annexure 1, that is 21st December 2021, shall order, your lordship. Kindly page 11, the relevant page is page 12, your lordship. That is the paragraph 3, your lordship. Kindly glance for a moment. On lordship, kindly glance page 12, your lordship. In my impugned order, the honorable single judge has mentioned, directed on query from the court regarding why petitioner is interested in the information shut. There is no answer, nothing has been shared in the petition. It appears the next paragraph 4, your lordship. It appears petitioner's grievance is not personal. As such, the read petition may be an element of public interest. It is released from the list. Petitioner will take steps listing the bench, division bench, hearing public interest litigation in event petitioner wants to prosecute the read petitioner, lordship. The present read petitioner appellant is the read petitioner of the single judge challenging the impugned order passed by the information commissioner in second appeal, your lordship. In second appeal,
What is the information you wanted? You were unable to tell the single judge that. What information are you seeking?
lordship, the OSEPA is constituted in 1993.
What is considered?
Orissa Secondary Elementary Primary Education Authority, OSEPA, your lordship, is constituted for development of the primary education in the state of Odisha, your lordship. In that program, the state government of MHRD department has contributed 60% of the country out of 100 total amount. 60% is given by the government of India, MHRD department, and balance 40% is borne by the government of Odisha. And in OSEPA, there are 3 types of employees are there: state level employees, district level employees, and block level employees. And all the employees appointed by the OSEPA are governed by the EC executive committee, your lordship. As per the EC, the employees appointed by the executive committee are getting salary as per the state government and central government employees, your lordship. That is the bylaws of the OSEPA. The state government employees and district level employees are getting same salary, whereas the block level employees, those who are working in the block level, are getting less salary than the state government employees and district level employees. Therefore, the present appellant petitioner, lordship, sought for information from the office of OSEPA to give information whether, as per the 30th executive committee, the decision has taken to give the benefits to the block level employees. Whether
who are you, sir? What is your locus? Who are you? Why are you interested in this information?
Here, the present petitioner is the general public. As per the is a public.
Why do you need this kind of information on which block level employees are getting how much salary? Why are you interested in?
Yes, that's right, your lordship. But here, what happened? As per the state government, the OSEPA has taken money as per the employees of block level employees in a different salary, different head, and given in a misery salary. Therefore, the present petitioner has sought for information from the OSEPA authority whether, as per the 30th executive committee.
Why do you need it? What are you going to do with that information?
My response to that effect, your lordship, the present petitioner is a citizen of India, has have rights to know whether the amount which is
Sir, we have right to ask you, what are you going to do? You have a right to know. We have a right to ask you, what are you going to do with that information? That's what the single judge asked you.
Here is the present appellant, the friend of the one employees.
Why doesn't he file a petition? When he files the petition in court, the counter affidavit will be filed. They will get to know everything.
May I pray one thing, lordship? May I permit to withdraw with liberty to file your
answer for the petitioner seeks leave to withdraw the present petition with liberty to seek appropriate remedies as may be available to the petitioner in accordance with law. This post office withdrawn with liberty is paid for. All right.
Obliged, lordship.
19, the appellant is a cooperative society. My lord, RTI Act is in
1 minute.
My lord,
No, 1 minute. 1 minute. You are withdrawing the just call. You have filed a writ appeal.
Yes, lordship.
What happened to the writ petition?
That is the writ lordship. That is page 12, lordship. Honorable single judge is directed. It appears the grievance was not a personal assess. The writ petition may have been element of public interest. It is relieved from the list. Means
then
that
what
was
happened?
pending, but as per this order, by the, my
All right. You say
contention is fine.
counsel for the petitioner seeks leave to withdraw the original writ petition civil 17560 of 2021. No, it's something else. Seeks to withdraw the original writ petition 37737 of 2021. Stop. The said writ petition is taken on board. You'll have to pass a separate order. And the present order will cover both writ appeal 254 of 2022, which is filed against the order dated 21/12/2021 passed by the single judge in the writ petition, as well as the said writ petition civil 37737 2021 paragraph. Then you say counsel for the appellant oblique writ petitioner seeks leave to withdraw the writ petition civil 37737 of 2021 with liberty to seek other appropriate remedies as may be available to the petition in accordance with law. The writ petition is disposed of as withdrawn with liberty as prayed for. Paragraph. Consequently, the writ appeal 254 of 2022 also stands disposed of. All right.
Obliged, Lords.
All right.
19. My lord, item now 19, the appellant is a cooperative society. My lord, RTI Act is not applicable to the cooperative society.
Where is that? When we have listed other matters. Correct?
My lord, other matter I have given order.
Ah.
My lord, yesterday serial number 77 was in, your
When is
lordship.
that? When is that coming up?
Next date, my lord, 30th August of 2023.
Notice returnable 30th August 2023.
Stay
The
order.
next date, the impugned order shall remain stayed. All right.
No delay in this case, my lord. I have
All right. Delay condo. All right.
not delay, no delay, but I have filed a condonation of.
Correct, sir. That's disposed of. All right.
My lord, interim order may be passed in this case. Other category.
We've just now dictated that, sir.
Sorry.
Item 20. 25th to 14th March, similar.
List on 14th March.
21. Your lordship has granted stay and fixed it to 27th March.
27th March.
And item 29 and 35 are same. 23. Like 23. That's Sartha Parida case. Fixed, your lordship has fixed it to 8th May.
Same order. Show us the order.
I have the disposal order. I'll give the lordship issued notice in similar case where it's a fast day disposal. So your lordship has disposed of all these matters.
No, but here there's no one entering appearance yet. This is
Not appeared, but those where they have appeared, my lordship may issue notice and fixed it 8th March.
It's returnable 8th May. There should be a stay of the impugned order till then.
24.
Then appears dismissal and opposition.
25. 25.
The delay is condoned.
25, your lordship has in a similar case issued notice and the matter has been fixed to 14th September.
All right. Notice returnable 14th September. There should be a stay of impugned order.
26. 26. 31 are rehabilitation matters. Your lordship has fixed it to March 9th March and the order.
List on 9th March. Simply say list on 9th March. All right.
26 and 31. Well,
Right.
31, I'm appearing on behalf of respondent, my lord. There is a delay of 212 days.
You're just calling it on 9th.
And
no, my lord, your lordship.
My lord,
My Lord,
While the caveat was in force, the writ appeal was filed and till date the copy of the writ appeal has not yet been served.
my Lord, is pointing a delay, that is COVID period.
Sorry, 9th March.
27.
The 27, you may pray your lordship may take up next week.
At the request of Mr. Kunti, list on. Twenty-sixth April.
My Lord.
28.
In 29, I am permitted to place my petitioner, my lord. The challenges the annexer for the order of the Honorable High Court single bench, my lord, without hearing the petition during COVID period, my lord. So I am permitted to the grounds taken in the writ petition. So I am permitted to date set, my lord. May I permitted to place the date set, my lord. And in the case of the petition is that he challenged the order dated 20th 11th 2012 of the extraordinary PH Division 1 moves regarding retirement on 30th and 31st March 2013 in view of change of date of birth from 20th February 2016 to 2nd March 2015 without following the principal natural justice. That is annexed 9 of the way, my lord, it is a fact that petitioner was engaged as NMR since 26/10/1979. However, he was appointed as a class 4 against the class 4 group D vacant post under works as establishment by the office order number so by the using of PS mentioned division Bhubaneswar, he joined the set post so. As per office order number, that is 4th August 92, he was brought over to regular establishment Khalasi on 4th September 92 against the post of newly created so by the chief so. It is a fact that constitutionally grades list dated 26, that is 6 in 1997, 30th August 2007, 11/6/2007 mentioned the date of birth as 20th February 1960, which accept the date of birth as 20th February 1960 as stated in the duplicate service roll manner. It is a fact that Provident Fund and the account slip accept the date of birth as 20th February 1960. Thus, any change of date of birth in the applicant from 20th February 1960 to 2nd March 2050 by the order response by the 20th 11/2012 of the Executive PA Division violates the principal natural justice with having civil, civil and penal consequences. That is a chronological events matter. That is the 20th 10/2012. The appellant being agreed to ignore the order response, that is 20th 11/2012 Executive PA Division Bhubaneswar filed way number so, which was renamed as Odisha High Court of WPC so. Thereafter, placed 30th July 91, that is officer that the petition was brought up to regular establishment Khalasi with effect on 4/6/92 against the post newly created and communicated by the chief so matter. The name of petition find place is still 13. Thereafter, placing the date 28th January 93, the application of admission for date dated 20th January 1993 in the Provident Fund for applicant was duly certified filled up by the head of office. The said form shows the date of birth as 20th February 1960. That is annex 4 of running page 29. Next matter, that is 20th July 1912. As per AG Odisha accounts confirmation slip, 20th 7/2012 shows that the date of birth the petition applicant is 20th February 1960. Annex 5 running page 38 mile. That is the 20th 6/1997 grades list of Khalasi at 20th July 1997 issued by the Executive PH Division number 1. Also shows the date of birth of the applicant is 12th February 1960. The name of the applicant finds that serial number at 220 at running page 32 of the writ appeal.
It's good you have taken a pause, sir. We're wondering when you are going to take a pause.
Mile.
So this is the dispute is about your change of date of birth, correct?
Mile, right.
When did you suddenly realize that you were born 7 years earlier?
It was the authority change my date of birth. I change of birth and then we should know retirement.
Service book, in your service book, your date of birth was entered as 2nd March 1953. correct?
That is the.
In fact, yesterday you completed 70 years.
That is the creation by the authority, my lord. All the gradation list issued from time to time. That is the date of birth. Suddenly have date of birth to change by.
Either way, you've crossed superannuation. Even if you take your date of birth as 60, you're superannuated now.
That's a fact. As per the date of birth mentioned from time to time by the gradation list, my lord, as accepted uncontroverted. That the date of birth that is 20th February 1960. How it will change suddenly as the retirement notice? Suddenly retirement notice change the date of birth. That is the annexer 9 running page 41. It also
Not suddenly, sir. 2012 they passed that order.
12 months they change my date of birth. The authority, the executive change my the date of birth. So that is without compulsory principal efficiency. Previously, all the gradation list, in the account slips, all the department documents shows that my date of birth has 20th February 1960. How it was suddenly changed?
All right.
Mile.
Yes.
However, in the meantime,
When did you retire, sir? As per your date of birth, when did you retire? Which was the date of your retirement? When did you actually retire?
27 January. 27 January.
That is 28th. That is February 2022.
When did you actually retire, sir? When did you actually retire?
I will take instruction back from the client.
What instruction? There's no question of instruction. You're in a writ appeal now.
Mild, you're right.
Yes. Let's in fact states that he actually retired on
2012. I've stated in serial
2013.
the impugn order itself states that he has consequently retired from service on 31st March 2013.
13.
That's
No.
That is at the age of 58. Please,
No,
60 because 53 to 60.
Due to interim order protected by the London Tribunal Code below, my lord, petitioner is allowed to continue retirement on 20th February 2020.
My God, you by interim order you continued for 7 more years. You are a very lucky person, sir. And government did not challenge it. You are an interim order, you continued for 7 more years.
Government known that mistake by the officers themselves. They have changed consistently, gradation maintained from time to time. That is the date of birth.
So that day itself, you should have just withdrawn your writ petition, sir. You should have just, when they allowed you to continue with an interim order for 7 years, at the end of 7 years, you should have withdrawn your writ petition. Infractuous. You got the entire relief. On an interim order. Final relief granted by interim order. And you are, instead of that, you persist and you are also now persisting in the writ appeal. Pointless.
Petitioner will get pension benefit for that period.
What was the date of that interim order?
Sorry.
Right. Writ appeal is directed against an order dated 16th August 2021 passed by the learned civil judge dismissing writ petition civil bracket OA number 133 of 2013. Paragraph. The above writ petition had been filed for quashing an order dated 20th November 2012 passed by the executive engineer PH division number 1, noting that the date of birth of the petitioner, noting that the date of retirement of the petitioner would be 31st March 2013. So, the case of the appellant was that his actual date of birth is 20 February 1960, and therefore he should be continued in service till 28th February 2020. Stop. Instead, the department had taken his date of birth to be 2nd March 1953. Paragraph. In response to the notice in the writ petition, a reply was filed by the opposite party state, in which it was contended that the service role of the appellant shows his date of birth to be 2nd March 1953, which had been accepted by the appellant, and on that basis, the notice of retirement had been served upon him for 31st March 2013, which was after his completing 60 years of age. Paragraph. The learned single judge rightly observed that if the appellant was aggrieved by this change of date of birth in the service records, then in order to establish that the date of birth was 28 February 1960, 20th February 1960, as claimed by him, he would have had to go to a civil court. Full stop. This being the settled position in law, the court is unable to see any error having been committed by the learned civil court. Paragraph has been mentioned here that during the course of the submissions, counsel for the appellant claimed that by virtue of an interim order passed in the writ petition, the appellant in fact continued up to 28th February 2020. Full stop. However, he is unable to produce a copy of such interim order. Stop. Be that as it may, if indeed there was such interim order, then the appellant already got the relief of continuing in service by virtue of such interim order. Full stop. Viewed from any angle, therefore, the court does not find any reason to interfere with the impugned order of the learned single judge. The appeal is dismissed.
Happy. Item 30, my lord, on behalf of Mr. Somyamesh, I pray for some time. There are some defect I'll remove in time. I may take up this matter any day next week.
No habit of carrying papers, sir. You're very privileged.
My lord, here.
That's all.
I extremely sorry, my lord.
What's the matter about? What is the matter about, sir? Tell us.
My lord, it is.
Didn't study it. Senior asked you to go and take time. You just carry the paper and ask for time. That's it.
Extremely sorry, my lord. I'll be prepared.
These are all opportunities, sir. At your age, at that time in the bar, I would get very excited if I got a paper book. Get very curious to see what it is. You're getting an opportunity to argue in a division bench in the High Court. Why are you letting go an opportunity? Frittering away. Today, if you had argued, got notice in this writ appeal, would your senior not be very happy with you?
Extremely sorry, my lord.
No, you don't have to be sorry for me.
This matter.
We are feeling sorry for
Next
you.
week
Yes, we're feeling sorry for you. Counsel for the appellant is stated to be in some personal difficulty today. List on 21st June.
32.
Impugned order is at annex 1 page 11. That the regarding that the enhancement of the age, that the resolution was first on 7/2/2015. By that time, he has retired from service on 31/12/2014. So the Honorable
What happened in Premlata Panda?
Premlata Panda, in respect of municipal corporation, that has been implemented only that, that in respect of this person, 2 months delay, by that time he has retired. That resolution when came into force.
No, nothing remains.
Hello.
Why should he not get the benefit of Premlata Panda?
Because that we have given it effect from 7/2/2015.
Why? That's the only point in the writ petition.
Yes, ma'am.
What is the basis for giving him the benefit only from that date?
That resolution was prospective, my lord, that.
No, that resolution date is 2014, sir. You decide one fine day that you will.
No, my lord, the state government in other that the retirement age was announced to 52 with effect from 30th June, my lord. So, that in respect of that, urban development department, they have adopted the resolution. With,
how can within departments make a distinction?
My lord.
That's not permissible. This appeal is directed against an order dated 23rd August 2021 passed by the learned single judge disposing of writ petition civil 12484 of 2016, giving the respondent the benefit of the resolution dated 28th June 2014, by which the government would enhanced the retirement age of its employees. Paragraph, the appellant, the respondent is apparently working in the Housing and Urban Development Department. Will stop the contention that this department could adopt a different retirement age, a different date for implementation of the enhanced retirement age is unacceptable, because for all employees in the state government, there has to be only one uniform retirement age. Paragraph, in that view of the matter, the impugned order suffers from no legal infirmity. The writ appeal is dismissed.
32 and 33 same.
Same, 33 also. All right.
34.
Right.
This matter, my lord, the matter relating to state had challenged the impugned order, your lordship will find at page 23. 22, it's 23. Matter relating to that application of that amended rule of rehabilitation assistance. And your lordship, though the issue has already been referred to the larger Honorable Supreme Court, and your lordship has kept some matters signed. Here, the Honorable Single Judge disposed of the matters directing to consider their application as per the pre-amended rule. Those the rejection order, the information sought for by the department to furnish the.
So anyway, this is pending for the larger bench. This petition, this appeal questions the correctness of the impugned order of the learned single judge on the question of applicability of the amended rules in relation to rehabilitation assistance. First off, the issue is pending before a larger bench of the Supreme Court. First off, the present appeal is accordingly adjourned sine die, awaiting the judgment of the Supreme Court of the matter. Liberty is granted to the appellant to mention the appeal for listing thereafter.
My lord, impugned order maybe.
I think so. No contempt. Is there a contempt filed?
No, my lord, the direction has been given for.
That's all. Unless a contempt is filed, there's no need, sir. Is a contempt petition filed?
No, contempt has not been filed as per the.
Then you mention it for listing, sir. After, if there's a contempt petition, if there's notice, then you can mention.
But
always file an IA.
The
in order for-
contempts are being disposed of at the strict way directing that comply the order within such and such period without notice even. First contempt, second contempt.
All right, just say, then simply say notice returnable 12th September. There shall be in stay of the impugned order till then. All right.
Item 36.
May I please your lordship? My lord, in this appeal, according to SR, delay has not been pointed out, but I
It's all
have,
right. Come up to the main matter now. What's the main matter?
my lord, in this appeal, the impugned order at page 62, the honorable single judge dismissed the petition on the ground that the appellants have not passed the OTET examination, Orissa Teacher Eligibility Test Examination. But in fact, the similar situated person have appointed pursuant to the judgment dated eight 2012, page 50, page 51. Your
The file you are
lordship kindly see last para.
not
12.
interested in.
Accordingly, this court quashes the notification dated 29/3/2012 and 16/6/2012 issued by the government of Odisha and Board of Secondary Odisha, Cuttack Bhide Annexure 3 and 5, and directs opposite party number 1 and the chief executive officer of the district to issue engagement letter as per the selection list of Shiksha Sahayaka prepared by them forthwith, and the candidates who will be engaged as Shiksha Sahayaka to be prepared themselves for OTET shall clear up the test by end of January 2013. My lord, this in this judge pursuant to this judgment, the other similar situated persons have engaged in the post of Shiksha Sahayaka, even though they have not passed the OTET examination.
There's no negative equality, sir. That should have been mistake in those cases. Mandatory. Yeah.
And I want to draw your lordship kind attention on another one document, that is the opposite party number 3 has called the appellants to issue engagement order. That
That's all
is,
right. There's no estoppel in these things. There is no estoppel. It's a requirement of law that you should pass the OTET. Paragraph. Sorry, you say this appeal is directed against an order dated 23rd March 2021, passed by the learned single judge disposing of writ petition civil. One 18028 of 2013. One 18521 of 2013. Paragraph. The petitioner's prayer for a direction to the opposite parties to engage him as
Shiksha
Shiksha Sahayaka in respect to the Jharsuguda Education District was negatived by the learned single judge after noting that the appellant had not cleared the Orissa teachers eligibility test bracket OTET. Paragraph. Counsel for the appellant sought to suggest that certain others who did not qualify the OTET have still been engaged as SS, and therefore the appellant too should be given a similar benefit. Paragraph. The court is unable to agree with the above submission. To stop, considering that the OTET qualification is a must, the fact that certain others may have got it would not inure in favor of the appellant, as there is no principle of single quotes negative equality, unquote. Paragraph. Since the appellant did not satisfy the mandatory requirement of obtaining an OTET qualification, the court is unable to find any error committed by the learned single judge. The writ appeal is accordingly dismissed.
37.
None appears dismissed. Delays condoned, dispensed with. Yeah.
38 is Sarthapada case, 38, 39 and 40. Yeah, the Sarthapada, my lord, that your lordship has
Sarita Parida.
Saratha Paridam.
Sarat Parida.
2015 ILR.
Yes, your lordship picked it 8th May.
8 May. Acha. You say notice, there shall be a stay of the impugn order. 8 May.
Well, 38, 39, 40.
41.
None appears dismissed.
42.
42, I have already appeared, my lord. Your lordship, page 14 is the impugn order. Disposed upon the very first day.
Sir, let me go back.
No, but here, your lordship may kindly see, my lord, what ground they have taken in this writ appeal. My lord, the same thing they will also place before the learned single judge. My lord, the circular annexure 5, my lord, may kindly be seen, which they have annexed. They are themselves disowning their own circular. My lord, a proceeding was initiated against me in 2017. My lord, that departmental proceeding is yet to be concluded. 6 years in the meantime has passed. My lord, the circular that which came into force in June 2021 says that there should be a periodical checkup, and if the seal cover has been adopted, if the proceeding is not concluded within 2 years, he will be given ad hoc promotion subject to other criteria. So, my lord, considering that and in consonance of the judgment of the Supreme Court in Chamanlal case, well, this learned single judge has passed order that he should be given ad hoc promotion subject to final outcome of the disciplinary proceeding.
Normally it's in seal cover, sir.
No, my lord. Your lordship may kindly see the circular.
The question of ad hoc promotion.
Yes, my lord. That is what the 17th June 2021 circular, my lord. Your lordship may kindly see.
I think there are criminal proceedings also against you.
No criminal proceeding. Let them file a single affidavit that any vigilance case or any criminal case. My lord, that is what they have stated in the ground. That a criminal proceeding pending. That is why they let them file an affidavit. That what is the proceeding, my lord. Except that disciplinary proceeding, no criminal proceeding.
Your lordship, page 14 is the impugn order. And what our circular says and what is the order?
My lord, there is no criminal proceeding.
Not necessary in absence of criminal proceeding. If a departmental proceeding is pending, then seal cover procedure is to be adopted.
Then what is
that is the law?
My lord, that is what the circular says, that if a disciplinary proceeding is pending and not concluded within 2 years, they cannot.
During pendency of the departmental proceeding, the honorable single judge are directed to give him regular promotion, my lord.
Not regular promotion,
yes,
ad hoc promotion.
Yes.
Subject to final outcome of
page 40.
Ad hoc meaning what? You still get the salary in the promoted post.
Yes, my lord. That is what the judgment of the Supreme Court. Your lordship may kindly see.
Order that for your page 14. Not ad hoc promotion. The court had directed to him give regular promotion.
Ad hoc promotion in terms of your circular. I'm not saying their circular. My lord may kindly say annexure 5. My lord,
what the single judge says is that's promotion subject to the outcome of the decision.
Yes, that does not mean ad hoc promotion.
That is not if this learned single judge, but according to their circular, my lord, they can give me a ad hoc promotion. Their circular, your lordship may kindly for a moment, your lordship may kindly see their circular. Annexure 5.
Yes.
Annexure 5. Annexure 5 is the circular of the state government.
Your lordship, annexure 5.
Just a minute.
I have annexed.
My lord,
clause 2, your lordship may see what that circular says. What are the conditions when we'll adopt that ad hoc promotion? If a proceeding under Rule 15 is pending, then we'll adopt the seal cover.
Yes. Then next, in case where
the employee has not come to even after expiry of 2 years from the date of putting of the department in which the seal cover was adopted, that may review the promotion subsequently.
So first you have to adopt seal cover.
That has been adopted in 2018. When this proceeding was, my lord, in 2018, when my batchmates were promoted, seal cover procedure was adopted. Till then, 2 years, within 2 years, that has not been concluded. So I am entitled for ad hoc promotion in view of this circular. And this judgment also says that
My lord,
No, no,
then
but then
your
there
lord-
is-
your lordship must see clause.
My
A,
lord,
B,
my
C.
lord, how long they will continue with this proceeding? My lord, proceeding.
No, no, there are conditionalities.
Yes,
that-
yes.
Hey, my lord,
Those
let them
conditions.
consider my promotion. My lord, these are the conditions, my other career, my CCR, my all these
No,
things.
no, but the single judge does not consider all this
Yes.
at all. The single judge on the very first day states,
My lord, what they
You
have
should be
taken,
granted promotion.
my lord, have they come with a ground that?
no, they should find.
No, no, no,
out. One
no, no,
minute,
in the,
sir.
in the writ
The
appeal.
difficulty of the first,
my lord.
first day disposal of
Yes,
this.
that is true, my lord, that is,
You just come to page 20.
yes.
Yes. What are the conditions?
If the delinquent officer has not defaulted in exposing,
I
disposal,
have not been defaulted.
who will, sir, first
My
of
lord,
all,
my
there
lord,
must be
my
given
lord,
a chance. This is your self-declaration will not
My
do,
lord,
sir.
have they taken it, taken a ground in
You
the
have
writ
to-
appeal?
you are not a writ appeal. They first be given a opportunity to file a counter affidavit.
All right.
How will they point out
My
to the
lord,
single judge that you satisfy all these requirements or you do not?
My lord,
How do you also know what basis they
My
deny
lord,
your promotion?
my lord, the proceedings started in 2017, my lord.
First of all, sir, two or three things. First of all, in terms of this circular,
Yes.
you can only be given an ad hoc promotion.
Yes.
Whereas the single judge asks that you should be promoted subject to the outcome of the disciplinary.
Well, let them give
It's
me
a very
ad hoc
different thing.
promotion.
No, no. Second thing is there are conditions.
I'm not saying, my lord, let them give me a regular promotion. Let them give me ad hoc promotion.
All right. We'll just set it aside then.
Yes.
We've heard both parties. You say counsel for the with the permission of both the parties. The writ appeal is taken up for final hearing. The present appeal is directed against an order dated 7th October 2021 passed by the London single judge, disposing of the writ petition civil 31501 of 2021 filed by the respondent on the very first day, and granting him the final relief of issuing a direction to the appellant home department to grant him promotion to the rank of DSP from the date his junior and batchmates got such promotion, open quotation, subject to the ultimate outcome in the disciplinary proceedings, unquote. So in other words, the learned single judge did not accept the settled principle that when disciplinary proceedings are pending, a single quote sealed cover procedure, unquote, should be adopted. Paragraph. Counsel for the respondent appearing on counsel the respondent drew attention of the court to an office memorandum dated 17 June 2021 issued by the General Administration and Public Grievance Department, Government of Orissa, on the topic of single quotes promotion of government servants against whom disciplinary proceedings are pending dash procedure to be followed, unquote. Para 2 of the said office memorandum is instructive and reads as under. Reproduce the whole of para 2. At the outset, it requires to be noticed that the impugned order of the learned single judge makes no reference whatsoever to the aforementioned OM. So stop. In fact, if the above OM had been noticed, the learned single judge would have required in the first instance the respondent, that is the writ petitioner, to show why he would be covered by para 2 bracket Roman small 2 of the said OM, which applies when disciplinary proceedings, as in the present case, have not come to an end even after the expiry of 2 years from the date of meeting of the Departmental Promotion Committee. Full stop. Even in terms of para 2 bracket 2 of the above OM, the granting of a promotion is only single quotes ad hoc unquote and not a regular promotion as has been granted by the learned single judge. Full stop. The second factor to be noted is that even such single quotes ad hoc unquote promotion is subject to the respondent satisfying certain conditionalities which have been spelled at clauses A to E of para 2 bracket 2 of the said OM. Full stop. The learned single judge had no occasion therefore to require the state to show why any of those clauses would apply in the case of the respondent before deciding whether the respondent had made out a case for such single quotes ad hoc promotion unquote, subject to outcome of the disciplinary proceedings. Full stop. A third factor which has been adverted to by the appellant in the grounds of appeal is that there is a criminal case also pending against the respondent, which connects to the respondent.
No, my lord, there is no reference of any criminal case that they have said that.
Sir, we have given the number also.
Yes.
Sir. For your kind information, come to para 3.
Para 3, they have said that criminal proceeding.
Not simply said, sir. Come to page 5.
Page 5 of the writ appeal.
Correct. We are able to read a PS case number. I don't know whether you're able to read it.
Against him, a departmental proceeding is pending.
Quintala PS case number. Quintala PS.
That's, my lord, that case, my lord,
that case
for your lordship's kind information,
that case not against her, my lord. That only departmental proceeding is pending.
not against me, my lord.
I see. Okay.
Departmental proceeding is pending.
Why have you mentioned that then?
That because of negligence in that
That is a case in respect of some other officer in another appeal. They have stated that ground that they have just
Correct. Anyway, you say that third factor. Since the learned single judge disposed of the writ petition on the very first date of the hearing, without an opportunity to the appellant to file any counter affidavit, but none of the above factors could be taken note of or dealt with. As a result, a relief has been granted to the respondent without any reference to the governing OM dated 17 June 2021. As a result, this court is unable to sustain the impunity order of the single judge. It is accordingly hereby set aside. The writ appeal is allowed, but in the circumstances, no resistance.
my lord, matter is remanded. My lord, unless
That was what we suggested to you in the very first. But you
Well,
insisted on arguing the matter.
No, well,
So we
un-
told you that we're now taking it up on merits.
unless, my lord, it is
Yes.
reminded that my lord, your lordship,
We've already discussed the whole merits, sir.
my lord, let it be reminded, my lord, at least, my lord, I have been suffering, my lord, I am under my juniors, my lord, I am working well. The lordship,
This
kindly,
is what we put to you right in the beginning.
my lord, let
That
it,
in all such matters.
my lord, since your lord,
Matters going on a remand, but you insisted on arguing.
sorry, my lord,
Ah,
let it,
just
let
show
it,
him this.
let
So
it,
you wait for us to finish 10 minutes of dictation
sir,
and then come up
No,
with
I
this
was
right
think-
idea that now you send me back.
no, my lord, I thought that
Yes,
you,
it's being unfair to the court, as if you do not know what the consequences are.
sorry, my lord, let it be reminded. Let it be reminded.
Just read that order.
I have also given him a copy.
I'm sorry, man. Let it be reminded. Let it be reminded.
Which are the dates there?
8th.
My only request is try and understand what the court is trying to put to you. Very often you're so full of your case, you don't even understand what is being put to you.
Well, one thing I request your lordship, I kindly,
Same order, same order.
and it will be disposed of within a stipulated.
सब वो अच्छी तरह दक्षिणा ते वरक का दिया है इसका तो सर
I may be pardon item number 41, just previous matter. I was late for half a minute
All right.
because
Tell us.
I have challenged the
judgment of the Honorable Single Judge under Annexure 3.
Yes.
The challenge party is at page 108 of the bill. Several writ petitions have been disposed of by this common order, having different categories of persons challenging a resolution of the School and Mass Education Department dated 26/12/2016.
Yes.
In category number 6, your lordship will find at page 108 of the brief that they are
What is when was the judgment passed?
2017.
And when did you file your writ appeal?
2019, I have filed also IA for condonation because in a writ petition which we have filed before this honorable court, the state government filed a counter stating that similar issues have been disposed of by this common order. And I received the counter of that writ petition in 2019. I have categorically stated in the petition, and thereafter I have filed this.
1 minute. The stamp report does not mention delay. Or
27/11/2019
1
I
minute.
got.
Just let's see your IA, sir.
I have filed the IA.
Just let's read your IA, sir.
Paragraph 2 or paragraph 3, page 2 of the IA. That the delay in filing the appeal is neither intentional nor.
No, 1 minute. Prayer clause, you don't even mention what the delay is. Where in this entire application have you calculated the days delay? How many days delay?
That calculation I have not given, but
have you made it somewhere in your file? Have you actually sat down and calculated limitation? Sir, in our times, I don't know. Maybe they were all making mistakes then.
Yes.
Unless we mentioned the days, actual days delay, they will not even number the application. We had a huge problem, sir. Maybe we should have come to you for advice.
Yes.
Then we could have actually filed without mentioning delay at all. Even 4 years delay, simply say there is a delay. Don't mention the time. Don't mention the dates. Very convenient. We made a big mistake. We should have come and
that I
consulted you.
received on 27/11/2019 and filed immediate thereafter.
You missed that. If I had listened to you, I would have simply told him 156 days. 4 years, 156 days.
That has been calculated till the date of filing of IA.
So now you know how many years delay.
I will have to amend.
No need to amend, sir. Now that you know, you have to just tell us. What were you doing for 4 years, 156
On
days?
27/11/2019, I received the judgment of.
How do we know that? How do we know that?
I received the count after receiving the counter in WPC number 202252 of 2018, wherein the department filed the counter stating about this judgment. So I obtained the certified copy and filed it.
Where have you said all this?
That is paragraph 3 of my petition.
Let's see, read that, sir.
That the delay in filing the appeal is neither intentional nor deliberate, but because of the fact that the present petitioners appellants have filed WPC number 20252 of 2018, questioning the legality of the order of the respondent number 1 dated 12/7/2018, by which the claim of the applicant's petitioners for their adjustment or rehabilitation against the post under Sarva Shiksha Abhijan scheme of National Child Labour Project, and on 27/11/2019, the counsel appearing for the petitioners of the said petition received the counter affidavit filed by the opposite party number 1, therein the respondent number 1 in this appeal, in which it has been stated that some issue has been decided by this honorable court by judgment dated 23/10/2017, WPC 525 of 2017, and batch of case.
So what is the date, sir? Now just make a note. Just make a note of this date that you put down. What is this date? 27/11?
27/11/2019.
Now come to para 4.
that after being intimated about the statement made in the counter and due to COVID-19 pandemic situation, the appellant's petitioners met the advocate on 20th/12/2020.
Now just put down this date, sir, by the side.
Yes, madam.
Ah.
And went through.
1 minute. What is the difference between that earlier date and the present date?
I could not understand.
The period.
27/11/2019 to 20th/12/2020. That is near about 1 year.
Near about
1 year, completely 1 year.
1 year or more than 1 year?
No, it took the 7 days shortfall for 1 year.
No.
Sorry.
My arithmetic is bad,
Yes,
sir.
yes,
Your
no,
arithmetic
no,
is
sir,
worse.
your lordship is correct.
Only Justice Raman
Seven-
has got correct arithmetic. He will tell us now.
1 month, 1 month.
My arithmetic is very poor.
13
He says 13 months, sir.
13 months.
What is 13 months is more than a year or less than a year?
More than a year.
So now we are in agreement. So now tell me, for 1 year, what were you doing? After you got counter affidavit on 27/11/2019. For 13 months, what were you doing?
I intimated the party. Party came in 2000.
So this is the problem. See, one is, first of all, you are not aware it's 4 years. So you're just drafting an application. Whatever can go past the court, let it go past. You're getting stuck with the bench which is going into all these details.
But what was the fact that I said? When they came.
Correct. So what do we do now?
As your lordship please.
Okay, all right. There is an inordinate delay of 4 years, 156 days in filing this writ appeal. The court has carefully perused the application for condonation of delay. Apart from the fact that the explanation offered is not at all convincing, there are also huge delays even in the narration of the relevant facts for the purposes of delay, which is unable to be satisfactorily explained by counsel to the applicant. Consequently, the court is not inclined to condone the extraordinary delay in filing the writ appeal. The application is dismissed. Consequently, the writ appeal is dismissed. All right. Thank you.
Item 43. In item 43, we have come against the interim order. Your lordship may see page 31.
In this case, copy has not been sought, and the main petition has already been disposed of in time.
That I am submitting. We have come against an interim order. In the meantime, that read petition has been disposed of.
So this is infractions.
So that I want to say. That I want to say is.
With the main writ petition having been disposed of and the present appeal being directed against an interim order therein, the present writ appeal has been rendered infructuous and is disposed of.
44.
May I please your lordship, my lord. Under Annex 1, the petitioner challenged the order of the Honorable Single Judge at page 17, para 6, my lord. The Honorable Single Judge has not inclined to interfere with the order, impugned order under Annex 5, wherein the provisional pension allowed in favor of the appellant, my lord, has been permanently withheld.
So your appeal is still pending.
Yes, madam.
So obviously, they can't take a decision on your pension till it's disposed of. Because you
My lord, there is a
against convictions.
only I have annexed one copy, my lord, of the Honorable High Court of Karnataka, my lord, a judgment at page number 55. That since the appeal is pending, my lord.
Yes.
That amounts to the judicial proceeding is pending. So the provisional pension which was allowed in favor of the petitioner, that
It's
should be extended,
post-conviction,
my
sir. It's post-conviction. This is post-conviction.
There's two submissions, my lords. The impugned order is against a show cause notice. My lord sees page 53.
Proposed to hold.
Proposed
Correct.
to hold. It's a
Correct.
show cause notice, so he was given 15 days time to reply.
Reply to it.
Please, my lords. And my lords, on the legal aspect, my lords, there's a judgment of this honorable court, single judge, my lords. He's held that if the conviction has not been stayed,
Correct.
then my lords,
There's no case. That's right. That anyway, well, let him reply to the show cause notice. You can
that's it.
put,
That's it.
let's not foreclose that.
Please,
You say the impugned order of the learned single judge has dismissed the writ petition filed by the present appellant, questioning the show cause notice dated 13th April 2015, wherein his entire pension and gratuity was sought to be withheld permanently as a result of his conviction in a criminal case, and there being no stay granted in the criminal appeal filed by him. Paragraph. Since it was only at the stage of show cause notice, the learned single judge has, and in the view of this court correctly, observed that the said impugned notice would be subject to the final outcome of the criminal appeal. Full stop. In the circumstances, the court is unable to find any error having been committed by the learned single judge. The writ appeal is dismissed.
46. 46, I'll also call this matter next week.
What's the delay, sir?
But the delay might night COVID and from during COVID period.
All right. 10th April. All right. At the request of counsel for the appellant, list on 10th April.
47.
The delay of 2 days was pointed out in by the stamp reporter.
How many days, sir?
2 days.
2 days. All right.
But 30th I have filed it.
It's all right, sir.
2 days.
Delays condoned. Yes, tell us.
But the entire my grievance in this writ appeal is the order of the Honorable Single Judge. I have filed an application under Section 7 of the Insolvency Act before the NCLT. The
I'm sorry to interrupt, but I'm sorry, Murad, I'm connecting virtually, not physically.
Yes, Mr. Nair.
Then, my lords, my application.
We are on caveat, but we've not been served because of the defects earlier.
I see.
And the matter is any case coming before the learner. So I was wondering, whether your lordship wants to exercise this. Writ is coming up for final hearing. Whatever it is, it can be, because when the appeal was filed, it was filed about a month and a half ago. It was not proximate.
When
so
is the next date?
Monday.
I see.
Well, my short grievance is I have filed an application under Section 7 before the NCLT.
No, 1 minute. If we keep this appeal, let's say on 10th April.
Yes.
And if it is still pending with the single judge, then you can move this appeal.
Fair enough.
The court is informed that the writ petition itself is listed before the learned single judge on 6th March 2023. In that view of the matter, the present appeal is adjourned to 10th April 2023.
Can I say something on very lighter matter? I was watching your lordships. And number 7 is Justice Gati Krishna. So when your lordship sit here, all these limitations and days and all counted. And we go back in memory to the stories of the past.
Okay.
So he used to say, you abuse me, but you tell your facts correctly.
But can I request for 11th a day later? Can we request for 1 day later, 11th?
All right, 11th. All right.
Oh, 10th is fine. Oh, so 10th is fine. I'm sorry.
10th is fine. All right. 10th is fine.
And my lord, very sorry to be virtual, but
no.
Since my lord is leading from the front of live streaming, so I wanted to see it.
All right.
Live streaming is only one. We are leading on several fronts.
We are only concerned with this court.
All right. Thank you.
Thank you.
48.
Same. Right.
49.
In 49, my lord.
Yes.
My lord, I have received the copy on 27/2/2023. As per your lordship's direction, they have submitted the copy on 27/2/2023. Therefore, I pray, my lord, it's time to file the reply to that.
All right.
27/2023.
Counsel, there's no reply, says the writ appeal. The writ appeal, there's no need for a reply.
I would as a
2000.
You're in 607.
my lord, writ appeal 586.
I see.
It is the identical matter, my lord, a common judgment.
No, will you be appearing for all of the respondents in all the other
my lord,
connected appeals?
Mr. Saurabh Sundar Das, senior advocate, will appear in other case, and Mr. Buddhadev Rautra is also appearing in.
No, I'm just asking because there are other writ appeals.
My lord.
I think Durgacharan Das is a respondent even in 607.
My lord.
So you will be appearing in all these.
All these.
Counsel appearing for the respondent.
In all these writ appeals, your lordship can dispose of it, my lord. Already your lordship has decided earlier, and your lordship demanded the matter to the honorable single judge with certain formulation that you have to decide this. That matter only if your lordship will go through that, my lord's the earlier judgment and the honorable single judge's judgment. So it can be disposed of, my lord.
Where is that earlier judgment?
That I have annexed.
2312.
My lord. I have made a comparison.
Annexure 4.
Annexure 4. Okay.
My lord. My state treatable your lordship turned to 5 W number 584 of 2022.
Annexure 4.
Before that, your lordship turned to Annexure 3, page 99. These are the honorable single judge order.
Right, same order.
Well, this was challenged in writ appeal. Then my lord's order is at page 129, 129. Well. And I will draw my lord's notice only paragraph 27, 28, and 29 of my lord's order.
Right.
30 and 31, 32.
So what has happened pursuant to this? It's still pending.
No, my lord. Thereafter, my lord, the honorable single judge, my lord, disposed of your lordship has given us an opportunity to file an affidavit. And we file an affidavit in pursuant to my lord's direction. And that has been rejected because earlier we have not filed affidavit when that writ was filed.
No, that order, the second order, what happened?
That is before my lord. That is the subject matter of challenge in this writ appeal.
So this writ appeal has to be heard then.
Yes, my lordship. Your lordship can dispose of your lordship.
Again dispose it off? No.
Yes, my
Your lordship.
Because your lordship has heard the matter and all your lordship has decided the issue in the first writ appeal.
Right.
And also decided to decide in respect of other part. But the honorable single judge, while deciding the second, has not answered the second part. Earlier, the matter which was disposed of earlier, on the same principle, the matter has been decided.
Your lordship, in WA number 584 of 2022, senior advocate Mr. S.S. Das, due to some personal difficulties, could not be present today. On behalf of the respondent, your lordship. May kindly be taken next week, your lordship.
तुम्हारी केस चल रही ना
5-8 ना.
हाई कोर्ट 4 चल तुम्हारी
Your lordship, time, 1 week time may be given.
All right. It's a counsel for the respondents. Seek time to address arguments. Interim order to continue. List on. Well, September.
Milord, interpel number 584, Milord. Interpel number 584, I have filed one intervention application that has been marked as flag D. IA number 986, that has come, but my name has not been reflected.
All right. You say that IA 1986 notice is accepted counsel for the other parties. The name of
Mr. R. Achary and Associates.
R. Achary, we indicated the cause. All right.
50. May I please understand? Well, this writ application has been directed against the order of the London single judge by directing the petitioner opposite party number 3 to cash the fees from a bond, which bond has not been declared as the bond of the panchayat even, not even that has been auctioned at any point of time, as it evident from Annex 4 of the writ application.
Which is a drayer? Which is the order you agreed by, sir?
But I agreed by Annexure 6 as well as Annexure 9 by the passed by the London's honorable single judge, rejecting my prayer to
So
consider
just come to this. You're Mr. Acharya, right?
I am Mr. Pandey, madam, for the petitioner.
I don't know. I don't know who has signed it. Just show him page 14, the hard copy. There's some corrections, correct? Let's see that. I don't know who has signed on these corrections. It's not your signature.
No, my lord. It is my associate senior, Mr. Acharya.
What is that correction? What does it mean, sir?
My lord, the order dated 1/8/2012, dated
22.
and the order dated 6/9/2022, my lord.
No. You have circled it and added something there. What does that mean? What does that circling mean?
Well, that is the writ application number has been modified. Mentioned. That has been corrected.
That other part has been circled. The order dated, that part has been circled.
A circular. It has been the goal village upon.
Order dated passed by the honorable single judge, madam.
So
That is the order.
what is the meaning of that circling of that, sir? What is that meaning?
Well, when I, with due respect, madam, when I approve this, the go to the confirm the, remove the defect. They say these are the defects to be removed in this way.
Perhaps I believe that they have challenged two orders.
And they
Yes.
confined it to one.
One only.
Which
That
is why I'm
the
asking you
latest.
repeatedly. Are you aware that you confined the prayer to one?
That is the
Yes,
latest.
madam.
Which
Yes,
is that
madam.
confined to which prayer?
6/9/2022.
September.
So you did not challenge two orders, you're challenging one
Yes,
order.
madam. Sorry, my lord. Sorry, I'm unable to misconstrue.
Get it back.
That is why.
Yes,
Now tell me which is the order you're challenging?
my lord, 6/9/2022.
This is the only order you're challenging.
My lords,
Let's see this order.
my lords.
Page 37.
That's from page 37, my lords.
So it's an order refusing to modify the 1st August 22 order.
My lords.
So even if this is what's the point in not challenging the 1st August 22 order?
We don't know what is the status of the writ petition now, whether it is still pending or.
It is disposed of.
And then these are all interim orders.
This is
It's infractuous. The present order writ appeal is directed against an interim
That's
order passed in the writ petition, which itself has now been disposed of. As a result, the present writ appeal is infractuous and is disposed of as such.
Well, let's make kind of please hear for a moment, my lords. I was not the petitioner before the London court below, my lords, before the London honorable single judge. Petitioner opposite part number 3 was a petitioner before the honorable single judge by misleading the fact to this honorable court that the pond in question is a government pond, my lords. He has been annexed certain documents basing upon which the honorable single judge passed an order. We come up with the villagers, my lord. Though we have certain amendments was made against being the writ application, we have not made in the party. We file a intervention petition before the honorable single judge. That has been dealt with and one honorable single judge held.
1st August 2022 finally disposed of the writ petition, correct?
My lords.
You have not challenged that order.
My lord, that's why in the prayer portion of my writ appeal, I have challenged both the orders.
Sir, just now when we asked you, you said you have confined it to one order.
Because, my lord, with due respect, my lord, maybe my fault, my lord. When I asked the SR that the two orders cannot be challenged, so the final order is the impugned order before the lordship. And this final order, my lord,
This
has
is not a
been dealt
final
with.
order, sir. I think you're mistaken. In a disposed of writ petition, you filed an IA.
My lords.
So without challenge, and you asked for recall of that 1st August order.
My lords.
That was dismissed.
My lords.
Which means the 1st August order stood.
My lords.
You have not challenged that in the writ appeal.
My lord,
When the SR asked you to avoid limitation, you said, no, I'm not challenging 1st August. This is the problem.
They made
You were time barred as far as 1st August. The SR pointed out to you, listen, the 1st August order, if you want to challenge, it's time barred. You wanted to avoid that, somehow get it numbered.
No, my lord.
So you confined it to one order. And the SR therefore noted it on the side, just show him that noting, that it's confined to one order.
Your lordship may give them liberty to file appeal against that 1st August.
Because, my lord, a fraud has been made to the honorable court by specific condition is
Sir,
that.
whatever, you have to be clear what you want to do. Just see the noting of the file.
My lords, that's why I have made two prayers to quas annexed to my lord, order dated
No, but
6/8, my lord.
you have undertaken before the SR that you're challenging only one order.
My lords, that mistake I have done, my lord. I cannot.
We're not sitting here to correct all your mistakes, sir. You have to correct your mistakes.
My lord, so that's why I prayed both and the SR said it cannot. You have to challenge the 6/1 order.
You are the lawyer, sir.
And
He is only an SR.
That is my humble submission. That is my fault, my lord. That fault I have
In your
committed.
desperation to get
That fault I have committed, my admit.
concede to anything that the SR.
I admit, my lord, that fault I have committed.
Whatever you have to do, you do, sir. We'll
But in your writ appeal, lordship may also modify the prayer. My lord, sir,
You have
two
to-
prayers, my lord.
First of all, you be clear what you want to do and file a proper application. If that is time barred, you file an application for continuation of that delay.
That application has been rejected, dealing with the order passed by the honorable single judge, deals with the order in the past in the writ appeal, my lords. Writ application.
Counsel for the appellant seeks time to rectify the numerous defects already there in this writ appeal. Sorry. 21st June. All right.
I say interim order, it's already there.
Lordship, interim order is there.
In the writ appeal.
Yes.
Yes, my lord. After satisfying that the fraud has been committed, my was placed to see the order.
That September order has been stayed.
No, both orders. You are appearing for whom?
I am for the opposite party number 1.
This is the petitioner before the.
Learned before the honorable single judge. Was the
What is
petition.
your stand?
Pardon, Lordship.
What is your stand?
Lordship, I am the petitioner in the writ petition.
Should we allow the writ appeal?
No, Lordship.
So what is your case?
Please come here.
Lordship,
Please,
I was
please, come here.
granted-
Come here.
Lordship, I was granted a lease pond for harvesting of the pisciculture, Lordship. After doing all the formalities, now the fish are in growth, and and by the obstruction of some villagers, it is not possible for me to harvest that fish, Lordship. That's why I file a petition before the writ petition, and Lordship, kindly glance at that order. That is, Lordship, page number 25. I am just placing the operating portion, Lordship, considering the
What has
submission.
happened in the meanwhile? What is happening today? What is the status quo as of today?
Lordship, that due to that interim stay order, still it is not operating.
No, nobody's allowed to fish there, is it?
Exactly,
Yes,
obviously, because there is a stay order, so it's, the petitioner, the petitioner was given liberty to catch the fish by the impugned order that has been stayed. So naturally, status quo must have been prevailed.
And Lordship,
With due respect, my lord, my learned senior should have come into the writ appeal instead of me, because he's not the point of the my lord the panchayat event. As the event for annexure for a moment, Lordship,
No, I am not
see
appearing
the
for
annexure for
panchayat. I am appearing for the government.
of the government. Government should have come in the writ appeal instead of the villagers.
Who's appearing for the panchayat now?
Panchayat is not noticed in this case. Is
No, they are
responding-
parties, sir.
They are part.
Their parties.
And notice has been issued to them.
Yes, knowledge
I
appeal.
don't know what is the service return.
What is it? Just find the service report.
For a moment, Lordship may see annexure for Lordship will clear from everything.
SR against respond number 2.
Yes, they've been served. The Gram Panchayat has been served. You filed this IA for vacating the stay.
Yes, Lordship.
You say you're the owner.
No, my lord. We are the villagers of the village, my lord. If tank was pond was digged, it is never a pond of the panchayat, my lord. But on the panchayat secretary, part number 3, the
Whose pond
panchayat.
is it? Whose pond is it?
But it is pond of nobody, neither the panchayat, nor from the government. It's a government land, my lord, government land.
No.
But not the point of the panchayat. Unless are poor. Lordship may kind of grants from it. Lordship will clear from everything. The entire case will be clear. Annexure 4, request 21, my lords, of my brief. This is a letter wrote to the IIC by the block development officer, video.
So you'll have to file a reply then. This is the whole case. He says this is not Gram Panchayat.
But he himself has annexed annexure 1. That is the record of right which reveals that it is a government land.
Government land, but not
So
panchayat land.
he says Panchayat cannot auction it.
My lords, that is
The
my whole
rights,
petition.
fishing rights in this pond
I
can't
don't
be
know
auctioned by the
whether
Panchayat.
any counter affidavit was filed by the BDO before the honorable.
No. It was not filed.
I see.
At the stage of admission, it was disposed of, my lords.
Oh, I see.
Lordship, if that is the grievance, then
Can it go back to the single judge then?
Yes, that is better.
That's better.
Single judge should deal.
All right. You see, the case of the appellate is that the pond in question, in respect of which fishing rights have been leased out to respondent number 1, does not in fact belong to the respondent number 3, Bharatpur Gram Panchayat. The sub-counsel for the appellant refers to a document at
Annexure 1. Record of right.
No. This is
Annexure 4, my lord.
That's
dated 23rd June 2022, which is written by the Block Development Officer to the IIC of Bali Chandrapur Police Station in Jajpur. Inter alia stating that the village tank in question does not belong to the Gram Panchayat. Full stop. Annexure 1 is the record of rights, which shows the pond in question as belonging to the government. Paragraph. It appears that the impugned orders were passed in the writ petition without opportunity to the state government to file a proper reply to the writ petition, explaining whether the pond in question is in fact a government property or belongs to the Gram Panchayat. Paragraph. In that view of the matter, while setting aside the orders dated 1st August and 12th September 2022, this court restores writ petition civil 17636 of 2022 to the file of the learned single judge in the roster bench, where it will be listed for hearing on 3rd April 2023. The present appellants who are seeking to intervene in the said writ petition will now be impleaded as opposite parties. Three to 6. Full stop. The state government will file its reply to the writ petition positively on or before 31st March 2023 with advance copies to the original writ petitioner, that is respondent number 1 hearing, as well as to the present appellants, to enable them to file a response thereto before 3rd April 2023. The learned single judge will now proceed with the matter on merits. Thereafter, full stop. Till interim orders are passed by the learned single judge, the status quo as of today shall be maintained.
Deeply obliged.
All right. The writ appeal is disposed of the above terms. Yes.
And we have sent the advocate's notice on 6 February 2023.
Notice returnable 21st April. So,
Item number 2, my lord. This is a disposed of case. Miss Pamirat
The
was
letter-
appointed as the, yes, my lord, she
Yeah.
stepped down.
all right. Ms. Pami Rath has declined to act as an arbitrator.
Your Lordship, I'm appearing through VC for the respondent.
All right. Justice B.K. Mishra, the former judge.
My lord, as my lordship.
Justice B.K. Mishra, the former judge of this court, is appointed as sole arbitrator to dispose of the disputes between the parties. The arbitration will take place under the aegis of the arbitration.
Obliged, your Lordship.
Is your lordship. The appointment of arbitrator, your lordship may kindly glance to page 40. Clause 13, that in case any dispute arising out of deal between the parties.
All right, notice returnable 5th May.
Obliged.
This is an application for appointment of arbitrator and the arbitration clause is at page 39.
All right, notice returnable 5th May.
Lordship.
Five, Lord, I am appearing for the petitioner in this case along with Mr. Pandit.
All right.
Just humbly pray, my lord, keeping the relationship of the parties, my lord, the petitioner and the opposite party, my lord. There's a family arrangement being worked out, even though the mediation, in my humble submission, has failed.
Okay.
So if your lordship would kindly call
All right.
this after 8 weeks, my lord, some solution may come out, my lord.
All right.
Next.
Although the report is that the mediation was unsuccessful, Mr. R.P. Kara, who enters appearance on behalf of the petitioner today, is hopeful that some settlement can be worked out between the parties. At his request list on 12th May. Or you want a longer date?
Longer date. Because the family arrangement has to be worked out.
All right. 14 July?
14 July.
All right.
Greatly obliged.
All right.
6. May please. This is an application for appointment arbitrator. The arbitration clause is page 27.
We have taken a ground for appointed graduate engineer. That is as per ABC construction decision. I have taken the ground, it's all right, but fairly I'm saying that
All right.
after ABC construction,
That's an order.
yes. So let's see, may appoint 70 lakhs.
Isan Mahanti mein senior
Or let's see, may Sarangi.
All right.
Santanu Sarangi or the
Shantanu Sarangi. It says S.K. Sarangi. S.K. Sarangi.
Santanu Sarangi, yes.
Okay. The same
Or
order.
Murali Pradhan, who
He's a former district judge.
MD Pradhan.
Santanu Sarangi mein.
All right. Mr. S.K. Sarangi, senior advocate of this court, as sole arbitrator. Okay.
7.
Item 7, Lordship, on behalf of the opposite party, received copy of the rejoinder and IA this Tuesday, Lordship. I play 2 weeks after to file a objection to their IA, Lordship.
What is the objection?
My lordship, actually, they have initiated the arbitration. They have appointed the arbitrator, and we have filed. We have objected to the arbitrator. They have not sent us a notice, and without our taking our consent, they have choose that arbitrator. And even though they have know that I have filed 11-6 before this honorable court, my lordship. So I filed the IA for the stay of the proceeding, and for that they want to file the.
Received it this week, Lordship. Lordship, may kindly accommodate once.
What is your objection to the appointment of an independent arbitrator? You anyway want arbitration to go on, right?
My lords.
So what is your objection to the independent arbitrator?
Our arbitrator, the arbitrator appointed by our, is a retired officer of the court, my lords, from the dispute is with regard to the jurisdiction.
You appointed him unilaterally, correct?
My lords.
So they're just asking, why don't we have an independent arbitrator?
Lords, I'm awaiting instructions from Punjab. I have sent the copy, my lords, and as per my instructions received, I need time.
Then you stay the further proceedings in the arbitration.
Yes, my lordship.
You say this IA, counsel for the opposite party needs time for instructions on this application, in which the petitioner points out that notwithstanding the pendency of the present petition, the arbitrator appointed by the opposite party is continuing with the arbitration proceedings. In that view of the matter, the further proceedings before the said arbitrator shall remain stayed till the next date. Moved on 12th May.
8.
We got more time, my lord, because
Twice they have taken time. On the 9th of December, they have taken time.
On the 21st of January, they taken time.
Last
And
opportunity.
my lord,
Last
this is a claim of 2015, went up to Supreme Court, and the Supreme Court has
Send it back.
said, no, as far as only the PA part is, principal amount has been paid, interest has not been paid.
Last opportunity, the opposite parties to file the replies within 4 weeks, rejoinder for the next day, 12th May. Mobilize.
Can I request for a date in April?
April is only one Friday, all are holidays, by some coincidence. All right.
9.
Minutes 9, I'm for the petitioner, my lords. Notice has
Yes.
already been issued. Nobody has entered appearance as of now.
Let's see
So
if
we
it's
have-
been served. Have they been served? We don't know.
Yes, my lords. At the last date, my lords have asked for issued.
Yeah,
notice.
yeah, returned after valid service. What is the claim?
My lords, is 1 crore 21 lakh.
Can we have Justice B.K. Mishra, former judge? Despite service.
My
of
lords, I am
none
paying
appears.
for a senior advocate, Mr. Justice, Mr. Dipi Nanda, or Mr. S.K. Sarangi, or Mr. Anyone who can do, anyone will do. I have no problems.
None
1
appears
crore
for the
21
opposite
my
party despite valid service of notice. Paragraph, the court appoints. It's a 1 crore plus claim, correct?
1 crore 21 lakh, my lords.
Or Justice B.K. Mishra, former judge of this court, as sole arbitrator to adjudicate the dispute between the parties, including the claims and counterclaims. The arbitration will take place under the aegis of the arbitration set. All right.
Much obliged, my lords.
Single. Item 1.
None appears to dismiss on prosecution.
Item 2.
Same order.
3.
Same.
Lordship, I have sought for questioning of the proceeding. The case under section 13(2) read with 13(1)(e) of the Prevention of Corruption Act is registered against the husband of the petitioner. The petitioner has been arraigned as an accused under section 109 of the Penal Code for abatement. The grounds taken by the petitioner are that she was paying income tax prior to the check period, and that has not been taken into consideration by the investigating agency. There were rent agreements, those have not been considered. Lordship, I pray that I will take those grounds at the time of discharge.
All right. Permitting the
That
petitioner to
liberty may
raise
be
all
granted.
pleas. Correct. Permitting the petitioner to raise all pleas at the appropriate stage.
Yes.
Petitioner dismissed. All right.
4.
None appears dismissed.
5.
Same order.
6. In this case, pay for quashing of a criminal proceeding due to compromise between the parties. Answer 2 is the my Rafanama, my lord. And all the injuries are simple in nature, my lord.
So this kind of a document is an informal document. You will raise this plea before the permitting the petitioner to raise all pleas at the appropriate stage. You have to file a proper affidavits. All right.
Yes, my lord.
All right.
To raise the before the law and court, my lord.
Correct. Correct.
Yes, my lord.
All right.
7.
Permitted to withdraw, my lord.
Dismissed is withdrawn. All right.
8. Item 8.
None appears dismissed.
9.
No instruction, my lord.
No instructions dismissed.
Item 8.
Tell me.
It's some time, my lord. Huge time, my lord, for appearance of the informant.
8.
No, they already sought time, sir. 22, 2019 also adjourned. This also adjourned. You raise all pleas at the appropriate stage. Permitting the petitioner to raise all pleas at the appropriate stage. Before the settled, or this affidavit is there. Raju Syed Mohammed. But what's the offense, sir? This is P.
307 and along with the other offences. In the meantime, also men co-accused also acquitted in these cases.
And judgment
Then
copy
you
also
better
I'll-
raise all the pleas, permitting the petitioner to raise all pleas at the appropriate stage in trial court. The petition is disposed of. Because this has Arms Act, everything, 307.
He
All
is
right.
a old person, 62 years.
Whatever, so 307 and all, we can't have a compromise. Yes.
So,
10 memo taken on record, no instructions dismissed.
11.
May it please your lordship. My lord, in this case, the petitioner has challenged the order, challenges the rejection of his prayer to dispense with his presence at the stage of accused statement, my lord. His prayer is under
By
section.
now it will all be over, sir.
No, my lord, it is at the same stage, my lord, for accused statement, my lord. Section.
No stay granted by this court, and yet it's not moving, is it?
My lord, I have instruction, my lord, the stage is at the same, recording of the statement of the accused, my lord. But in this case, my lord, the petitioner filed an application for dispensation of his presence at the stage of accused statement. Earlier, the petitioner was granted dispensation under section 205 CRPC, my lord. Dispenser of his presence, my lord. His application was rejected.
Correct. It's correctly rejected, sir. You're the accused, correct?
My lord.
How can you be?
My lord, section 313, there is a proviso to section 313B says that, provided that in a summons case where the court has dispensed with the personal attendance of the accused. In this case, my lord, already section 205 has been allowed, my lord. So
It's okay.
it may also dispense with his examination under clause B, my lord.
Yeah, this is a discretion, sir.
My lord, this is summons case, my lord, and the present accused, my lord, I have also the reason was that I was ill on the said day. And I am also not a resident, not a local resident, my lord. My lord, to that extent, I have a judgment of this honorable court.
We'll give a date, you appear on that date. You tell me which date it's convenient to you, can appear on that date.
Or by VC also he can be examined.
I don't know what's an accused statement. I don't know. But one appearance you make before where is this court?
Sir, my lord.
So it's all right. You're in Calcutta, you can come down, sir. We'll fix it on a Saturday, you go there.
It will not be required, my lord. His counsel can represent it's a summons and also the allegations are 294 and the maximum punishment.
One hearing can appear, sir. Nothing's going to happen.
I have a judgment of this honorable court also, my lord, where it says that once the dispensation is allowed under section 205 of CRPC, and it may be favorably considered, my lord.
The court directs, the court, while not being inclined to interfere with the impugned order of the trial court, the court directs that the petitioner will appear before the trial court on 21st April or 22nd April.
A little.
22nd April, Saturday. All right, 22nd April 2023. Any further requests for the exemption from appearance will be made by the petitioner in accordance with law, which will then be considered by the trial court on merits.
12.
A copy of this order be sent to the concerned trial court. The petition is disposed of. Right.
Published.
Well, my lord, no instructions.
No instructions dismissed.
13.
None appears dismissed.
14.
None appears dismissed.
15.
None appears dismissed.
16.
Same order.
17.
The vigilance counts.
17.
Vigilance counts.
17. The correction be carried out as played for that ICC number. All right. A fresh order be issued. Right.
18.
May I please? In a bridge for the was the cognizance order dated 56 and with basis of the compromise, my lord.
Where is that compromise, sir?
Offense under section 294, 354A, 417, 323, 490.
Where is the compromise?
The annexure 2, my lord.
Which matter are you appearing in?
Item 18.
Criminal MC 1390, correct?
1390, my lord.
There is no annexure 2.
2 series, my lord. Defect, my lord, defect not comply, my lord.
No, where is the compromise petition? This is the handwritten one.
Yes, ma'am.
That you
Grant
file,
answer.
you
Yes, ma'am.
raise the plea before the trial courts, permitting
Yes.
the petitioner to raise all pleas at the appropriate stage of the trial court. The petition is dismissed.
Yes, ma'am.
19,
None appears dismissed.
20,
None appears dismissed.
21,
Same order.
22,
Same order.
23,
Same order.
24,
None appears dismissed.
25,
My lord, no instruction.
24 is the criminal IA number, sir.
25, my lord, no instruction.
No instructions dismissed. All right.
26,
None appears dismissed.
27,
None appears dismissed.
28,
Same order.
29,
Same order.
30,
Same order.
31,
Same order.
32, 32,
Same order.
33,
Same order.
34,
Same order.
35, 35,
Same order.
36,
Not placed, my lord.
Not dismissed.
37,
37, Lordship, petitioner has been discharged infructuous.
Infructuous dismissed.
Great.
38,
None appears dismissed.
39,
Same order.
40,
Same order.
41,
No instruction.
No instructions dismissed.
41,
Already over, sir.
42,
Dismissed.
43,
None appears dismissed.
44,
Same order.
45,
Same order.
46,
Same order.
47,
Not this, ma'am.
Not dismissed.
48,
Dismissed.
48, 49,
None appears dismissed.
50,
Not this, my lord.
Not dismissed.
51,
None appears dismissed.
52,
Lordship, item liberty may be granted to raise all the pleas at appropriate stage.
Permitting the petition. All right.
53,
None appears dismissed.
54, 54,
The criminal remains in none appears dismissed.
55,
None appears dismissed.
56,
May I please? My lord, I have challenged the order of cognizance, my lord. Enter criminal proceeding on the ground that it is bar under section 300 of the CRPC, my lord. The petitioner has faced trial before the learned court below and acquitted from all the charges, my lord. After that, the vigilance department has filed another FIR on the same cause of action, my lord, and filed charge sheet, my lord.
You offer the vigilance department.
My lord.
Huh. What do you say?
He has to file an application before the trial court, raising all those pleas that he has been acquitted in the similar
No,
case.
why should he have to
All
face
your
all
lordship.
of that?
Your
If
lordship.
he in fact has been acquitted, why should he face all that?
So far as our case is concerned, your lordship kindly have a glance to page 36. 37, second
Yes.
para.
Yes.
It may be mentioned here that the photograph has case and so and so was registered against the present petitioner on the report of branch manager. Our case is registered on the basis of a particular private person that he has been his loan.
You
fund-
file an appeal against that acquittal, sir. You can't have a fresh case now registered. You want to file a reply?
Your Lordship.
Counsel to the Vigilance Department seeks time to file a reply. Seeks and is granted 4 weeks time to file a reply. Interim order to continue.
Obliged.
List to the roster bench. On 27th April. None appears dismissed.
58,
Same order.
59.
Same order.
Your Lordship. Questioning of criminal proceeding. The matter has already been compromised. The informant has appeared. Your Lordship. That is the affidavit I have filed. Affidavit filed by the informant. Your Lordship.
The informant is filed an affidavit.
Yes.
You are appearing.
Yes.
And is also represented by counsel. Full stop. She states that there has been, the matter has been amicably settled between the parties. Accordingly, put down from the Pereira clause and all proceedings consequent thereto are hereby quashed. Got it.
60,
None appears dismissed.
61,
Same order.
62.
This petition arises out of a complaint case, my lord. My lord, all the pleas I can raise at the time of premium of charge. The only, my lord, prayer is while issuing, my lord, while taking cognizance, simultaneously he has issued NBW.
All right. You say while permitting the petitioner to raise all pleas at the appropriate stage, the court directs that the petitioner will appear in the trial court on 21st April 2023. And for further exemption from appearance, you're out on bail or you're not?
No, my lord, because I have challenged the NBW.
Right.
That is the settlement.
And if a bail application is filed by then, it will be considered in accordance with law.
And then, my lord, it is a case of, my lord, 307, he has took cognizance. The law is, my lord, while issuing, my lord, while taking cognizance, the magistrate cannot issue NBW.
So
he has to issue first summons, then, my lord, BW, then, my lord, NBW.
Anyway, you've got a stay since 2018, it's been stayed.
My lord.
That order is over now, it's worked itself out. I'm just giving a date on which you appear.
Then, my lord, I will take into custody, my lord.
You apply that day itself. You apply that day. You
the magistrate has no jurisdiction.
You appear with an application.
Well, the magistrate has no jurisdiction to grant bail, my lord. That's why, my lord, your lordship may consider it is a complaint case.
No, but you'll have to surrender then.
Yes, I will surrender. Your lordship has fixed the...
When that's what, 21st. Okay. Then you say on which date the petitioner will surrender.
Surrender and maybe released on bail, my lord. Your lordship may grant that. Because NBW is bad in law.
And if he can't grant bail, then you have to apply in the appropriate court for that.
Yes. Then, my lord, I have to go to the sessions court, my lord.
Whatever. So you surrender on that date.
Then I will take custody, my lord.
So you decide what you want to do. Then you just take, you say, permitting the petitioner to raise all pleas at the appropriate stage, the application is disposed of. All right.
I'm for OP2, my lord.
Yeah.
OP2, my lord.
All right.
Obliged.
53, no instruction.
Memo taken on record, no instructions.
64, no inspection.
Same.
64,
no instruction.
Huh?
No more.
All item नहीं
65.
नहीं mo 65 टा मोर
65. 65.
हाँ 65.
65.
My lord, here I have challenged the order of cognizance. There are two matters, my lord. One is relating to the petitioner, who are private persons, and the second is relating to the police officials, my lord.
Which is the second matter?
My lord, second matter, those police officials have gone to Raulkela to execute to apprehend the accused, my lord. And when
this second matter is what? 1740 is one matter.
And 2212.
No. That is not. We are now called out. 65 is 1702. 66 is 1740. Anshuman Mishra. 65 none appears.
66, my lord. May I please, your lordship? Here, my lord, I am challenging the cognizance order, my lord. What happened in this case, my lord? The bank has taken a rent from the opposite party and the family members. and bank has already paid all the dues. During that period, they come to the bank, and after expiry of that period, they come to discussion with the branch manager, and the branch manager said to him that you will file an application. I will move to the head office. Thereafter, after this is being a public institution, I may be vacated. After that, suddenly the complaint case was filed against me under section 420, 294, 448, 441, 506 IPC. Even though, my lord, after the expiry period of the lease agreement, the bank has already in every month deposited the said amount in their account. So, my lord, what happened? The complaint case filed against me as a branch manager. So therefore, I may be allowed to either your lordship may direct for a dispose of the matter within a stipulated period. Now I am already transferred from that place to another place.
You already been transferred?
Yes, my lord.
Oh.
That is why.
All right. Despite service of notice, none appears on behalf of the opposite party number 2 complainant. Stop. The present petition seeks the quashing of an order dated 12th March 2018 passed by the SDJ in Berhampur in 1 CC number 520 of 2017. Filed by the respondent, but opposite party number 2, taking cognizance of the offences under sections 441, 448, 294, 420, 506 IPC against the petitioner. Paragraph. The background facts are that the petitioner was at the relevant point in time branch manager of the Allahabad Bank, which had taken the premises belonging to the opposite party number 2.
The then manager has
the then managers on lease. The property belonging to the opposite party number 2 at Bhapur on lease. Full stop.
At present, my lord, the bank has already vacated.
Yeah, it is stated that since then the bank has already vacated the premises. Full stop. In relation to the same subject matter of the complaint, a civil suit number 3835 2018 was at the relevant time pending before the Civil Judge Senior Division Berhampur, which was an eviction suit. Now, with the bank having vacated the premises, even that suit has become infructuous.
My lord, that perhaps that suit has already been
disposed of. That suit has already been disposed of.
As per instruction.
Yeah. As per the instructions of counsel of the petitioner. Paragraph. With none opposing the present prayer of the petitioner, who has since been transferred to another branch, the court sees no purpose being served in keeping the criminal case against him pending. Full stop. Accordingly, 1 CC number so and so and all orders pursuant in the said proceedings, including the impugned order dated 12/3/2018 of the SDJ in Berhampur are hereby quashed. The petition is disposed.
Deeply well.
67.
None appears dismissed.
68.
No instructions. No instructions dismissed. 69 is yours.
My lord, I am sorry, my lord.
No, that's all right.
Lord, here I have filed 2 cases, my lord, challenging the same order for taking cognizance in a protest petition, my lord. But initially, the complainant has filed a complaint case which was sent for investigation under section 156(3), my lord. And your lordship will kindly turn to page 26. The police, after investigation, have filed the final report as the petitioners in this case are the police officials of the Mangalabag PS. They have gone to Raulkela to apprehend the accused, who is the husband of the complainant, my lord.
No, there was somebody appearing for the opposite party earlier.
He is appearing for the complainant, my lord.
I know, but where is he today? All right. You say counsel appearing for the opposite parties is not present in court today. Interim order to continue. List before the roster bench on 2nd May.
70.
None appears dismissed.
71, your lordship may dismiss on the ground that second revision in guise of 482 is
Not maintained. All right. The present petition seeks to challenge an order already passed in revision by the Additional Sessions Judge Chhatrapur. To stop a second revision petition in the guard of section 482 petition is not maintainable. To stop leaving it to the petitioner to seek other appropriate remedies, the petition is dismissed.
Seventy-two, may I please, Your Lordship, I am appealing for the opposite party. Number 2 is the complainant. My instruction is matter is closed before the learned court below.
None is appearing for the petition. None appears for the petitioner. Dismissed on prosecution.
Obliged. I am for the opposite party. Number
Yeah.
obliged.
73, my lord, the final form has report that no evidence is found against the petitioner, accused person. Then if no protest petition also filed, then he filed a complaint case. The cognizance was taken without notice to the accused person. The cognizance are taken on 294 and 500 and 506 IPC.
All right.
Your
opposite, last 1 minute, sir. Mr. Das Parida was appearing for opposite parties. You see, the record shows that one Mr. V.S. Das Parida, advocate, was appearing for the opposite parties.
Item 73. Does it the
Yes,
brief has been transferred from us?
Today, the court is informed that the briefs have been transferred from them. Fresh notice be issued to the opposite parties, returnable before the roster bench on 8 May. Interim order to continue.
74, may I please, my lord. The quashing of a proceeding, my lord. At the time of occurrence, the opposite petitioner too was minor, and after attaining the age of maturity, the petitioners were married, and a marriage already been registered before registering officer, my lord. And in the meantime, they have also blessed one girl child, my lord.
All right. Counsel, the petitioner states that the parties, the petitioner and opposite party number 2 have already been married.
Petitioner number 2, both are
petitioner number 2 and opposite party number 2 have now been not opposite party number 2.
No matter.
Petitioners 1 and 2 have already married.
Yes, madam. Yes.
And are also blessed with the child. An affidavit has also been filed to that effect. That view of the matter, just take from the prayer clause, and all proceedings consequent that are hereby quashed. All right.
75.
25, my lord, infructuous.
Infructuous dismissed.
76.
Lordship, the trial has attained finality.
All right. Infructuous dismissed.
Obliged.
77.
None appears dismissed.
78.
No instructions dismissed.
79.
May I please, your lordship?
Yes.
I am in BC, my lord.
Yes.
My lord, here the petitioners have challenged the my lord initiation proceedings.
Yes.
And they quash the proceeding because my lord, on self transaction there are 2 proceedings are continuing. Where my lord, kindly see the annexure 1 is the proceeding which the offense and the date of transaction, everything, the same transaction has been again initiated by the CID crime branch. So my humble submission before lordship, my lord, is a case of double jeopardy. So the second FIR, second transaction, which are the same set of transactions, same set of date and occurrence on offenses. My humble submission that it is covered by your lordship judgment and honorable Supreme Court. So my humble submission, the second FIR.
Right. Should be quashed. I think they let them be given one chance to file a reply. If not, we'll take it on the next date. You see, the counsel for the state seeks and is granted 4 weeks time to file a reply. Rejoinder filing before the next date. Interim order to continue. A list before the roster bench on 9th May.
Grateful. I am obliged to be here in
Yes, I just noticed. Noticed. All right.
All are fine and all are happy, and
Okay.
it's all convenience. The
All
staffs are good and they are also providing money.
All right. All right.
Great.
Right.
Item 80.
Item 80 and 81 on behalf of Mr. Vishwajit, kindly taken up one week after.
At the request of counsel, the petitioner listed for the roster bench on 10th May.
82.
Item number 82, my lord, I am appearing on behalf of my senior Mr. S.S. Das. So kindly be taken up this matter in the next week. Because my senior was unable to attend today.
All right. Again, counsel, the petitioner stated with some difficulty today. List on same day, 10th May. All right.
Obliged.
83.
May I please, your lordship? Here, my lord, the petitioner is a political person, my lord. On the date of election and counting, my lord, the block chairman election, my lord, at the same date, same time, different police jurisdiction, the complainant have filed 4 FIR against the petitioner. And the present case selling before your lordship is, my lord, by the annexure 1 is under 307. The injury do not corroborate the FIR story also.
So let you take all the pleas at the appropriate stage.
Now, my lord, my lord, the petitioner is holding a post, my lord. And basically, now, my lord, compromise, your lordship may keep it pending, my lord.
307 and all, I don't know, sir.
My lord, 307, your lordship kindly have glanced, my lord, page 14 and 15 of the brief.
You take those pleas at the appropriate stage in the trial court, permitting the petitioner to take all pleas available to him at the appropriate stage in the trial court, the petition is disposed. Right now.
Your lordship may kindly consider at the time of framing of charge, my lord.
Whatever, sir, whichever stage, we've said the appropriate stage. You can raise it at any stage, right?
84.
May I please, your lordship?
Yes, please.
My lord, in the petitioner challenging the order of cognizance, my lord. And in this case, notice was issued to the opinion of he did not appear, my lord. Your lordship come to page 32 of the judgment of the London Family Court, my lord. I am reading, my lord, that opinion 2 is already, she is a married lady, my lord. She has 2 children and is residing with her husband, my lord. I am reading that on the basis of uncontroverted evidence of the OP and a witness is Subrat Khande, it is quite evident the petitioner number 1 is presently residing with her husband, parents, brother-in-law, sister, and with 2 children, where the OP is residing with her parents.
See, you can always point this out to the court, sir. This is the monthly maintenance case, is it? What's the order you're challenging?
The challenge the order of cognizance, my lord. As because
under which this is, where is that?
She is a married lady, my lord, but during subsistence of valid marriage.
How does one? So you will have to point it out to the trial court, sir. Permitting the petitioner to raise all pleas at the appropriate stage of the trial court. The petition is disposed of. Right.
85.
Lordship, Mr. Naik has some personal difficulty. Can you take it up next week or any other?
All right. Counsel, the petitioner stated in some personal difficulty. List on 11th May.
Obliged.
86.
Before the roster bench.
86.
Hannah is dismissed.
87.
Permitted to raise all points.
Permitting the petitioner to raise all pleas at the appropriate stage. Right.
88.
May I please? This is a case, my lord, on the basis of compromise, this petition has filed. Both the petition and opposite 3, both are already married and out of their whole 2 children as blessed, my lord.
All right. The affidavit of the opposite party number 2 stating that she has already married the petitioner and is residing happily is placed on record. Counsel for the opposite parties for the petitioners also adds that they are blessed with 2 children. That we matter take from the prayer clause and all proceedings consequent thereto hereby quashed.
89.
May I please, your lordship, my lord. On a complaint case turned to GR case, my lord. I have filed this application for quashing of the entire proceeding, my lord. On the ground, my lord, this is entire arising of the civil dispute, my lord. Your lordship may kindly see annexure 4, my lord. And relevant page is page 36. That there is an agreement for sale of the property, and out of consideration of 10 lakh rupees, I had given the advance of 2,14,000 rupees, and rest amount will be paid.
You're for the opposite party.
Yes, your lordship. I have no instruction from the opposite party number 2, your lordship. No connection. A very old case.
And the case is also that is filed, my lord, by me, my lord, for return of those money, my lord. That is in annexure page 38, your lordship.
How much is he claiming?
My lord, 2,14,000 rupees is paid, my lord. neither he returned back the money nor went for a registration of the land, my lord. My lord, that is why I filed
You
a
are
suit.
now in occupation. You are in possession, I think.
Not possession. I have the document in possession as per the my lord.
Why has he filed a criminal case against you?
And a criminal case because I have possessed the documents what was given at the time of
So
agreement.
468, 471.
For 6
So
you lordship may
take
kindly
all
see-
these pleas at the appropriate stage. Permitting the petitioner to raise all
Page
pleas.
37, may kindly see page 37. That's 36, my lord. He shows that because I had given the advance amount, he has delivered the position that is in 2015, my lord. That agreement was held, my lord.
Anyway, permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed of.
Obliged.
90. The petitioner in custody for more than 2 years and 4 months, your lordship. And the allegation under section 302, 201 and 34 IPC, your lordship.
Now, what was the stage of the trial?
Well, it's out of 34 witnesses, 12 have been examined. The IO has not been examined.
Here, your lordship, I have been
The
implicated only on
informant is yet
circumstantial
to be
evidence, your
examined.
lordship.
And the medical officer, apart from them, there are some more witnesses.
Last
No, independent witness. Last time we wanted to find out if independent witnesses have been examined.
Yes, ma'am.
They've been examined.
Independent.
It's all right. So today the court is informed that the independent witnesses have already been examined and only the IO remains to be examined.
No.
Yes. No, my lords. Apart
There are out of 34 witnesses, your lordship,
14 have been examined.
only 12 have been
12
examined,
have
your
been
lordship. The IO, these inquest witness, the constables and the doctors. And some of the seizure.
You see, the court is informed that the 12 witnesses who have now been examined. Last time you said 14, I've recorded as 14.
No, it's 12. As
12 witnesses, 12 prosecution witnesses who have been examined includes the independent witnesses.
Yes, sure.
The petitioner has been in custody since
I'm in custody since 28/10/2020, your lordship.
28/10/2020. Keeping in view the above factors, the court directs that during the pendency of the trial, the petitioner will be enlarged on bail, subject to the conditions to be subject to the satisfaction of the trial court. The petition is disposed.
Pardon, my lord. Item 31, I am reaching in late, my lord, due to the lead problem. You kindly take note, my lord.
Yes.
My lord, in this case, my lord, the present petitioner challenging the proceeding, the question of the proceeding, my lord. The present petitioner is owner of the vehicle, my lord. That vehicle already, your lordship kindly peruse annexure 1 series, the Rati running page, annexure 2, my lord, running page 15.
So there is no stay. This matter was never listed even once. What has happened to the case? Now the case must be over.
Till today, not final charge sheet not filed, my lord.
That's all right.
That's very interesting.
Then it's okay. So permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed. All right. You can connect me. Namaskar, sir.
I may please your lordship, my lord.
Yes, please.
This is an application to revive the previous writ application. The previous writ application was withdrawn because there was no instruction, and the liberty granted by lordship, if there is a cause of action, you revive the petition. However, we filed a fresh writ application instead of filing to revive the application. Then that writ application has been disposed of, Lord C, annexure page 6 of the order of this honorable court, granting me liberty to file an application before your lordship to revive the previous application.
I see. Okay, all right. All right, notice in this.
Yes.
But doesn't have to go before us, or because
Yes,
it's not a
it is
partnered matter.
Division bench matter, now therefore it has come to before lordship. So matter has to be revived by the division bench.
Oh, it will be heard by a roster bench.
That's what.
Yes. No, but my lord, that is heard by roster bench. Only the difficulty is that I have to revive the previous writ application. I filed a fresh writ application. That
All
was
right.
my
You
mistake.
say- All right, all right, all right. For the reason stated, the application is allowed. And writ petition civil 20402 of 2010 stands revived. It will, then in that writ petition, you say today it's been revived by, for order passed from this IA. List before the roster bench. On 21st March.
Obliged.
Item 2. Item 2 again, one application for revival of the restriction. The Lordship would kindly see the ground on which it was disposed of, the lease has expired. In fact, the lease was renewed. I filed the renewed lease along with my interim application.
But now you have a 5-year lease, is it?
I have filed. It was in fact prior to the disposal that was there. So I have filed it.
But whether Mr. Ratha, whether the cause of action survives?
Yes, the Lordships are correct. If a Lordship will that way take up the matter also, I'll just after revival, I'll take a liberty to reapproach the Honorable Court if the fresh cause of action arises.
Then this itself will dispose of like that. You
That's
say
right, my lord.
the
Lordship may-
application is disposed of with liberty to the applicant to revive, to file a fresh petition if any cause of action arises in future.
Lordship may just revive it and pass the order, my lord. Otherwise, it's disposed of in the IA. I don't mind if a Lordship passes.
The IA is good enough, sir. Good enough.
All right, all right. Since the SOP is operated, unless a fresh cause of action arises, I am not.
Exactly.
Correct. One just thing can I bring to my lord's notice? The person against who is after me, he has filed a petition that's still pending in this Honorable Court to close down this shop.
Okay.
So should your lordship be pleased enough to take up along with that or dispose it of? It's my duty to bring to my lord's notice.
I know, but that's not before us today.
So that's there, it's pending. That is WPC 14788 of 2050. It is posted to 21st of March.
So that day you can point out.
Three. Only may record that it's pending, Lord. May say that you did not bring it to the notice.
No, it's all right. If it's 21st March, it's very soon. Yes.
Item 3.
None appears dismissed.
4.
Again, none appears dismissed.
Item 5.
All these cases under monetary limits, same order may be kindly passed. List I have given 5, 6, 7, 8, 9, except 10.
All right.
Except 10, 11, 12, 13, 14, 15, 16, 17, 18.
No, 18,
Right.
18 I'm appearing, notes.
18
respondent.
Is on 12th March.
No, 18th I'm appearing for the respondent, notes. Here the order has already been given effect to Milods. Has been operating for since a decade, Milods. And your lordship would appreciate, even though this has been made subject to the result of this ITAT, this has been operating for the last 10 years, Milods.
Oh, I see.
The High Court's order is on 14/8/2019. This was given effect to on.
So this IA, we can say item 18. In the other matters, you passed this order.
This last matter is fixed on 12th March.
But the appeal order has also been given effect to, Milods. The appeal was in 2012.
All right.
The appeal order is effective on 2014. The High Court's order is on 2019. That's much prior to that. 5 years earlier, Millard was given effect.
So item 18. No, but the last item, our list is item 17. Which is this item?
18.
18, sir. 18.
Orders.
Next page.
18 for orders.
Oh.
It is fixed on 12th March.
No, I don't think that's there.
No, that's ITA. 144.
But no one appear on behalf of the opposite party.
Oh, here it's shown as 17. I don't know why. All right. Item 18, this IA number 136 of 2019. It's pointed out by Mr. R.P. Karal, Learned Counsel appearing for the respondent SSC, that appeal effect has already been given to the order and appeal. And therefore, the appeal itself, the present appeal has been rendered infructuous.
Infructuous.
Full stop.
Yes.
Consequently, the application is disposed of as such.
Your lordships are also disposing of the appeal.
Then it is cancelled.
It is infructuous.
This was for revival of the appeal. So this application is disposed of.
Yeah, application is disposed.
Greatly obliged.
One more.
10.
One more survives is 10. Though there is a legal issue, my lord, but your lordships may dispose of on the ground that doesn't come within the scope of review. Issue is, my lord, if a person remains in charge of an higher post, will he be entitled to the salary of that higher post? In the same organization, my lord, in fact, a contrary view has been taken by this judge, by this High Court also. But I'll be duty me to point out, my lord, the office.
Which item are you?
Sir, I'm item 10.
10.
Sir, left out after the income tax matters, my lord, the only matter survives is item 10 of your lordship's board. Item 10, sir.
Show me the list. This, it's very different.
Sir, item 10. Sir, legal issue, sir, is a matter which has been, there is a conflict of decisions that whether a person remains in higher post shall get a higher salary or not.
Just see the item 10 here.
10.
See, this item 10 is different.
Item 10 is different than other ITM matters.
I'm referring to review petition 216 of 2019.
Where do you get it now?
Oh, brief is there of philosophy. I just point out, my lord, why I'm saying that though I have I have a great legal question to advance. I am handicapped by two facts, my lord. The office has pointed out a delay of more than 1,000 days because the defect was not cured. So it's my duty to point out that there's a defect has been pointed out, that the delay of 1,000 days. Your lordship can note the point issue that whether the person who is in charge of a higher post will get the higher salary if he's in charge for the period.
Correct.
That is the issue in this case. The same organization, my lord, the High Court has taken a contrary view, say that they will not be entitled to a higher post. This was an earlier view was taken that has confirmed the order of the tribunal. Two things stands in my against me. My lord, of philosophy turn to page 16. But I would like to canvass, but I am the face of 1,000 delays. I am
correct. We'll confine it to the facts of the case and say it's not constituted proceeding.
Yes.
All right. While the delay in filing the present review petition is inordinate and not satisfactorily explained, and the court is not inclined to condone the delay, it nevertheless clarifies that the orders of which review sought will not constitute a precedent for future cases.
Grateful, sir.
The review petition is dismissed with the above observations.
Grateful, sir.
All right. Namaste.